In the Solway Firth, just off the coast of the United Kingdom, sits the massive Robin Rigg offshore wind farm. It is an array of massive turbines designed to generate continuous power from the ocean winds. To keep structures upright, engineers use a specific foundation. A massive steel transition piece slides over a hollow monopile driven into the seabed. To lock them, high-strength grout fills the gap. Once cured, friction alone supports the turbine's weight. In 2010, at Robin Rigg, that grout gave way. The downward pressure overwhelmed the connection, causing the 120-ton transition pieces to slip down the piles. Fixing the sinking foundations required a highly complex offshore remedial engineering intervention. The final agreed-upon cost for the repairs came to €26.25 million. Someone had to pay that bill. E.ON, the energy company that owned the wind farm, naturally looked to the contractor, but the builder argued they had executed the project perfectly. The resulting legal battle exposed a massive vulnerability in how modern engineering contracts are written. The contractor was MT Højgaard, an experienced Danish construction firm. When they built the foundations, their execution of the design was flawlessly delivered. They designed the connections in strict accordance with DNV J101. That document was the internationally recognized standard for offshore wind turbine design, and the exact engineering standard the employer specifically mandated. The builder adhered to good industry practice. They hired an independent certifying authority to approve the designs at every single stage. When the case first went to court, the judge explicitly cleared the builder of professional negligence. The foundation's failure was not caused by poor workmanship or bad materials. It happened because the mandated international code contained a critical mathematical error. If a contractor is legally required to follow specific rules, and those rules are wrong, why should the non-negligent contractor bear the financial liability? That question reached the highest appellate authority in the United Kingdom. In 2017, the UK Supreme Court delivered a ruling that dismantled the builder's defense. The judgment isolated a harsh reality for the construction industry. In design and build contracts, perfectly following the mandated code does not protect you from liability. To understand how a contractor can be held liable for someone else's mistake, we have to look at the exact nature of the error inside DNV J101. This document served as the authoritative certification guideline for offshore structures. Section 9 of the code contained a series of equations used to calculate the interface shear strength of a grouted connection. One of the critical variables in this math is delta, which represents the height of the surface irregularities on the steel. The code provided a specific, hard-coded instruction for this variable. It explicitly stated that for rolled steel surfaces, delta should be calculated as 0.00037 multiplied by the outer radius of the pile. That specific constant was wrong. It overestimated the holding strength of the connection by a factor of about 10. By plugging the mandated number into the mandated formula, MT Højgaard calculated that their connection design possessed more than enough axial capacity to handle the immense load of an offshore wind turbine. Relying on that math, the engineers determined they did not need to include shear keys, a physical reinforcement structure we will examine shortly. They proceeded with a smooth, friction-based connection. The builder did exactly what the blueprint asked, and because the blueprint's math was flawed, the physical collapse of the foundations was mathematically guaranteed from the moment the design was drafted. With the engineering failure isolated to the J101 standard, the dispute shifted away from the physics and onto the text of the contract. The core of the conflict was located in a multi-authored section of the agreement known as the Technical Requirements, or TR. This document contained two deeply conflicting demands. The first clause, TR 3.2.2.2i, legally required the contractor to prepare the detailed design of the foundations in strict accordance with the J101 standard. The second clause, right next to it, was TR 3.2.2.22. This required that the design of the foundations ensure a continuous lifetime of 20 years, without planned replacement. MT Højgaard built their legal defense entirely around this contradiction. They argued that these two clauses were mutually exclusive. It is physically impossible to engineer a foundation that will last 20 years, while simultaneously using the mathematically flawed J101 equation. Initially, the Court of Appeal agreed with the contractor. They ruled that the 20-year lifetime clause was too slender a thread to override the explicit, highly detailed mandate to use the standard code. The logic seems sound. A court cannot logically enforce an absolute 20-year performance guarantee if the employer forces the builder to use a blueprint that guarantees failure. Or so the industry thought. When the case reached the Supreme Court, Lord Neuberger, the president of the court, evaluated this apparent paradox. Instead of looking solely at the technical error, he looked to history. He traced a long-standing legal principle. When a builder promises to deliver a specific finished result, they remain bound by that bargain, even if the plans provided by the employer make achieving that result difficult or entirely impossible. To prove this, the judgment cited the 1876 Supreme Court case of Thorne v. Mayor of London, which dealt with the construction of Blackfriars Bridge. The contractor there followed flawed specifications provided by the employer, resulting in massive delays and expenses. The House of Lords ruled that a contractor who bids on a defective specification only has themselves to blame if they failed to verify its practicality before agreeing to the work. Similarly, in the 1886 hydraulic engineering case, a firm was ordered to construct cast iron cylinders according to the client's plans. When the cylinders fractured due to an unavoidable flaw inherent in the mandated design, the court still found the manufacturer liable. For well over a century, courts across the UK and Canada have consistently arrived at the same conclusion. If you agree to a fitness for purpose obligation, promising the final product will perform a specific task for a specific time, that promise legally obliterates any defense of merely following the provided blueprint. Armed with this precedent, Lord Neuberger turned back to the specific text of the Robin Rigg contract, and there, buried in the introductory provisions of the technical requirements, he found the exact language needed to finalize the ruling against M.T. Højgaard. The court focused heavily on Section 3.1 of the technical requirements document. Clause 3.1i explicitly stated that the environmental conditions and the engineering standards provided, which directly included the J101 code, were only the minimum requirements of the employer. The very next clause, 3.12, legally transferred the burden of engineering verification entirely. It stated that it was the responsibility of the contractor to identify any areas where the works needed to be designed to more rigorous parameters. This allowed Lord Neuberger to resolve the paradox. Because the contract explicitly designated J101 as a mere minimum, the requirement to build to the code and the requirement to ensure a 20-year life were not actually mutually exclusive. The court's logic is uncompromising. When a contract imposes two seemingly inconsistent standards, the contractor must assume the more rigorous of the two standards prevails. The less rigorous standard is simply the baseline. Therefore, M.T. Højgaard was contractually obligated to discover that the mathematical equation in the international code was flawed. To achieve the 20-year guarantee, they were required to unilaterally decrease the delta parameter themselves until the math actually matched physical reality. By writing the word minimum next to an engineering standard, a client shifts the absolute risk of structural physics and any mathematical errors hiding inside third-party codes directly onto the builder. Let's look back at the physical foundation. If the contractor had successfully identified the mathematical error embedded in the international standard, what were they actually supposed to do? To meet the 20-year guarantee, engineers needed to abandon smooth friction and implement shear keys. These large steel weld beads act as mechanical ledges inside the tubes. When grout cures around them, it locks physically, safely distributing downward force and completely bypassing the flawed equation. Because they did not include shear keys, Lord Neuberger delivered his final conclusion. A foundation relying on a flawed equation, even one mandated by the client, was not truly designed to last 20 years. The Supreme Court reversed the decision of the Court of Appeal. They ruled that M.T. Højgaard breached their contract, and the €26.25 million liability was placed squarely on the contractor. The Robin Rigg judgment forces us to confront the due skill and care fallacy that plagues the construction industry. Following established good industry practice, hiring independent certifiers, and executing the provided blueprints perfectly will successfully protect an engineering firm against a claim of professional negligence. But those exact same practices offer absolutely zero legal protection against a breach of contract claim, as long as an absolute performance warranty is written into the document. In modern design and build construction contracts, the contractor is operating as the ultimate guarantor of physical reality. If you sign an agreement guaranteeing a specific outcome, you are liable for the physics that dictate that outcome, even if the client is the one who supplied the math.